Okay, so I'm going to go through like kind of a little bit of a brief presentation and then I will take questions. I would ask though that if anything is related to like a specific property, a specific address, um, there'll be contact information at the end of the presentation. So I just would suggest that you schedule, we do 15-minute free consults. I don't typically like to talk about individual matters in front of a group for a lot of reasons. For those who are not familiar with me or my firm, my company is called Pritzker Law Group, affectionately known internally as PLG. We're a high quality legal service firm. We do real estate, business, and government relations in Philadelphia and the surrounding counties. Just a little bit about us for those who don't know us. I run PLG with my twin brother, Adam. We're both lawyers and just have some unique experience having worked in the public sector. I worked for a city council member legislating for a number of years. And Adam and I both worked for the president judge of the Superior Court, which is the second highest court in the state, and then both went into private practice. I worked at a big private law firm in the city, and then we started PLG in 2017. We're a certified women-owned law firm, and we've been fortunate enough to win a number of awards for our work, and we've won a number of awards related to tax assessment appeals as well. That just all to say we know what we're doing. Getting right into it with tax assessment appeals, most important thing to note is the deadline. The deadline is always the first Monday in October. So it's like kind of like a birthday. It's the same every year. Sometimes it's the 7th, sometimes it's the 5th, but it's always the first Monday in October. This year, it's the 7th. So with that said, we have some time to get these submitted, but they have to be submitted on or before the first Monday in October. Typically, when we do an intake call with folks, again, we do these 15-minute free consults. So, you don't have to pay for the call. You don't have to worry. We'd like to help evaluate it. And we basically will look at the property to see, if we think we have a good case. We always, not always, but within the last year and a half, 2 years, with the amount of appeals we do and the way that we've negotiated with the city, we try to get everybody to get an appraisal or speak with an appraiser. I'll go through in a second, like what are good cases and not good cases. The city does require that if your property is assessed at, not if it's worth, but if it's assessed at $1 million or more, you need an appraisal. We often suggest you get an appraisal. Otherwise, we have to spend the time pulling comps. And truthfully, the best way to negotiate with the city has been with these third-party appraisals. The city kind of has been a bit challenging to work with as far as their transparency and sharing of information. So we will recommend appraisal companies. I know you guys all, for the most part, are familiar with an appraiser and appraisal companies, and that has really streamlined not only like the legal costs on this for clients, but also our ability to really negotiate with the city in providing these appraisals. We don't need them before we file an appeal. We can supplement the record after the fact, but we like to make sure that we also can support any reduction with an appraisal. It's sort of the best way to go about that. We also will look at the sale price. Actually did a consult call this morning where the client or the potential client had paid, $2.5 million for the property, and the city had it assessed at 2.4. And they had paid 2.6 for it like in May. So that was not a great case because the city will look at the sale price, especially if it's recent. Now, if the sale price would have been far less than what the city has it assessed at, then that would have been a good case. A lot of people got these FLRs, first level reviews, and also the tax assessment appeals in the mail recently. If you haven't got one, we can still file an appeal. You should let us know that as soon as possible. If you haven't gotten one, most people got them mailed to them within this week, last week, and the week before that. We tell everybody that, with a first level review, it's an FLR. It's different than the formal tax assessment appeal. A first level review is basically you saying to the city, hey, listen, I don't really agree with what you assessed my property at. Do you want to take another look? However, they are non-binding. So we also make sure we file the full tax assessment appeal, because if the city either doesn't respond to the FLR or they do and it's not favorable, or sometimes they'll say, no, we're going to stand by what we wrote. There's no then teeth to move forward. So we've had clients in the past that have only submitted an FLR and it doesn't really put them in the best scenario. Also, the city doesn't get back to you very quickly on any of this. So if you don't file the full tax assessment appeal and you only filed a first level review, they're not going to get back to you by the time in October where the formal appeal is due. So you're going to have sort of missed your window. I'll also say if you decide on your own to like, hey, I think I'm really smart, I can do this myself. I would probably advise against it for a lot of reasons, but if you choose to do it, just, in full transparency and trying to be a good human being, please do not click non-oral hearing. You never want to be in a situation where somebody is deciding your case behind closed doors. If you have the city or the Board of Revision of Taxes making a decision on your appeal without an open and transparent process, the likelihood of it being fair is probably a negative percent. So, can everybody just mute themselves if you're not on mute? Sorry. I just, again, wouldn't recommend you do a non-oral hearing. That some people will tell you that that gets you it through quicker. I know that people have been advised that, but truthfully, they are making decisions behind closed doors, which is not a way to go about anything. Our process is we submit the appeal. We then usually wait about 6 months to reach out to the evaluator. We're still processing and negotiating 2023 still. So there's an incredibly long backlog. It's a big hurry up and wait game. When we file your appeal on time, we want to make sure that you let the bank know if you have bank financing for a property, because you actually only have to pay the amount for the year before. You don't have to pay the increased amount. A lot of times banks, especially if they're not local banks, which a lot of them are not familiar with that. So we will write a letter on our letterhead to your bank to let them know, hey, listen, here's the city rules, and to make sure that they are not overpaying or they're taking from your escrow. That has happened for a lot of clients if we're not sort of proactive about that. We then, once we get, time has passed a bit and we negotiate, get through 2023, we start to work on 24 and 25. We basically reach out to the evaluator. A lot of people wait until a hearing and then they try to go into a hearing. Most of our cases, we negotiate with the city well before a hearing. We typically would, if we went to a hearing, we'd be waiting like 1.5 to 2 years to even get to a hearing. And by that time, you kind of want to spend your time negotiating with the city. Given our relationships with the city, given our understanding of this work, given the fact that we've done this for, it's going on 8 years, we sort of know that trying to come up with a settlement with the city is 10 times out of 10 a better option than going to a hearing that is really short, typically like uncomfortably adversarial, and like doesn't usually result in anything beneficial. If you know me, I'm very competitive and I like to win. So if I'm telling you like we should like not go to a hearing, it's not because I don't want to do the work. It's not because my team doesn't. It's because it's not worth our time, and the success of that is typically not beneficial. I go in front of the Zoning Board of Adjustment regularly, so I'm a big fan of like hearings and administrative boards, but typically through this process with the tax assessment appeal, it's better to work and negotiate with the city and deal with the evaluators. Also, because we're lawyers, we're able to deal with the attorneys for the Office of Property Assessment and the Board of Revision of Taxes. If you're not, you typically wouldn't ever interface with them. And a lot of times for us specifically, that moves the ball forward. If you try to do it on your own, you might have a hard time figuring out who the evaluator is or understanding how to get a hold of them or spend a lot of time on your own. We have some clients that, unbeknownst to us, we're trying to do some outreach of themselves. And I can tell you that it can just be very frustrating if you're not sure who to reach out to. And again, we try to speak lawyer to lawyer so that we can move this forward. And again, because we're attorneys, we're able to do that. Again, we like to have an appraisal. It just moves the ball forward a lot more quickly. And then typically, if we come up with a settlement with the city, we don't make any decisions unilaterally. Even though we have you sign a power of attorney to negotiate on your behalf, we do speak to you when we get a settlement offer from the city and say, hey, we spoke with the evaluator, we spoke with their lawyer, this is what they're offering. We think this is a good deal because this, or that, or we're going to push back a little bit unless you don't want us to. And then ultimately we have you sign the withdrawal form, or we ask your permission. If you want us to sign it, say you're traveling or whatever you want us to do it, we'll handle that as well. That's sort of the way that this gets finalized. And then we work with the city to get a recertification. If the amount that you paid the year before was more than what it is now, we'll submit a refund petition or we'll make sure that a credit gets uploaded to your account. If we go to a hearing, which is rare. We'll obviously prepare for the hearing. We'll prepare you for the hearing. For any of those who have worked with me on like late file tax abatements, you know that we do prep calls before everything. Make sure that you're comfortable and you understand sort of what you're walking into, so it's no surprise. Just an example of some good cases, and I will take your call regardless of if it fits into these conditions or not, so that I can help explain to you what it is. We can have a conversation about it, and also so that you can ask me questions. I try to be very generous with my time. So, I'm always happy to answer questions and to get people familiar with the process, even if you're like, I don't have a good case, or I don't have a client for this right now, or whatever. I'd rather this stuff for the future, as opposed to like not understanding it and not having us as a resource. And no questions are dumb questions. I've done my entire career has been dealing with real estate, government, and the city. So I don't expect anyone to know this, but again, I'd rather you ask me and be informed than not. So feel free to reach out. If it's not urgent, we'd appreciate you letting us know it's not urgent, so that we don't try to fit it in on top of other urgent matters, especially with the upcoming deadline. But please don't hesitate to reach out. You're never bothering me. It's not a headache. I really don't mind, and neither does my team. Some good cases: if you purchased a property for less than it's assessed at, that's always a good case, because obviously an agreement of sale, or the deed is a really good indicator. And it's like anything, the best way to show value is what someone paid for it. There may be instances where you overpaid for it, or a client overpaid for it. Maybe there was a bidding war, maybe this, maybe that. There are times where we can show that you did overpay for the property, or you thought you were going to get rents on a rental property that you didn't get. In that case, we'll look at rent roll, cap rates, things of that nature. But typically sale price, especially if it's less than what the city has it assessed at, is a good case. Again, we always want to get an appraisal. We work with a variety of different companies that have reasonable price points depending on what the asset is. And a lot of times the appraisal does a lot of that work, pulling comps. And we talk to the appraiser usually ahead of time to say, hey, do you think this is a good case? What do you think the value is? And any appraisal that's legitimate that can show a lower value is a really good case for us. And we've been very successful in negotiating those down. People ask me all the time, what does the city look at? I can tell you that I'm not all the way sure, and I don't know if they're all the way sure, just because I've seen them try to explain their assessment process, and it has taken hours to explain, which I don't think it should. But typically, they're supposed to look at size, location, condition, and use. That's what we look at. We look at how big is your property, how big is the land, where is it located, what is the use of the property, and what's the condition in it. Usually they assign a certain price per square foot based on condition, whether it's average, above average, below average. And we want to also make sure that sometimes the city doesn't have access to going inside your property. So there are times where the property will be, above average condition, even though it's definitely not, or it's below average condition. And we have done site visits with the city upon request when we think it's reasonable, and when the client's comfortable with it, we attend those, obviously. And that can also help move the needle forward as far as reducing the assessed value. Location's important, and use is important. Sometimes that city doesn't look at the use permits to make sure of it's a multifamily or a single family, and making sure that they didn't think it was something it wasn't. There's also times we do a lot of appeals if you have an abatement on a property, but it wasn't implemented, so your tax balances are incorrect. A lot of people don't realize that the abatement is a completely manual process. It's not just a matter of submitting an application and then it's like all good to go. There's a lot of back and forth that happens between the Office of Property Assessment and the Revenue Department. Our office does a lot of like manual implementation of these, making sure we get in touch with the correct evaluator, making sure it's actually correctly implemented on both OPA's site and revenue, and that we make sure that the taxes are correct. Separate and aside from that, we'll talk about abatement. I'm going to talk about abatements like really briefly at the end, but that's important to check. I always tell people this, especially realtors that I work with, when they work with clients and developers who say they have an abatement. You either have an abatement or you don't, and there's paperwork and it's implemented on the city's site. It's not like there's no some other place it's located. It's either in writing or it's not. It's either implemented correctly on the website or it's not. If you're not sure what you're looking at, totally reasonable. We know what we're looking at. And I've had people call me at a settlement, FaceTiming me, being like, is this the right thing I'm looking at? I'd rather you call me and ask me than assume something, especially because for financial reasons, if you don't have an abatement and you thought you did, it can really change the basis and the potential tax liability of a property. I tell a lot of people it's better to apply for a tax assessment appeal than to not apply for one if we determine it's a good case. We can always withdraw if the appraisal doesn't come back what we thought, or if we don't really agree to the city's value, or we didn't have all, we weren't provided with all the facts. You always want to meet city deadlines. You can always supplement things, including the abatement, if the construction costs change or the project change, or you added on to it. What is really difficult, and we do a lot of these, but it takes a lot of time, is doing anything where it's filed late. There's a process for that. I'll talk about it very briefly, but it's better to apply and then withdraw and meet the deadlines than not. Most of these cases, as mentioned, we settle because that's the key to success with these things. It's not waiting a year and a half for a hearing. If the key to success was waiting a year and a half for a hearing, I promise you I would do that. So just keep in mind that we do try to get these settled ahead of time so that we can move on. And you're only paying on the prior year's amount until it's resolved. So you're not getting hit with, although your property may have gone up, you're not actually realizing any of that from a tax liability perspective. I'm going to talk about tax abatements really quickly, and then I'll answer questions. I just get a lot of questions on tax abatements, and it kind of ties in with all this. And it's always good to remember, especially with realtors, because I know you guys get asked about this a lot. So the tax abatement is based off the building permit. So it basically, if you don't file for a building permit, you cannot get a tax abatement. If you file an easy permit, but you don't put the cost of construction on the easy permit, you can't get a tax abatement. The building permit is the key, and it's not the CO. It's not, when the construction's done. It's not when your contractor says. It's based on the building permit. All the deadlines and the timeline around the tax abatement are based on the building permit issuance date. That's it. There's no other thing about it. Again, it's not the CO. It's not anything else. It's not when the paint is dried. It's the building permit issuance date. So I tell people always think 30 days. If you always file the tax abatement application within 30 days, you'll never miss a deadline. There's really no reason to wait on filing it. If you don't know what you're doing, please reach out to us. We charge a very, very low flat fee to do the work. It's not a big money maker for us, but it's a really good service, and it's important for investment and development in the city. New construction, you have to file within 60 days that the building permit was issued. Not again when the construction was done, or 60 days from when you feel like it. It's within 60 days of the date that the building permit was issued. Every building permit has a date on it that's issued. It's in the top right corner usually, or the top left corner, and it's 60 days from then. If you're not tied into the Eclipse account, you're not going to be able to see the building permit. I think you always, when you're working with a contractor, you have a client who's worked with a contractor, you always want to get copies of licenses and permits so that you have them, you make sure they were done correctly, and that things like this you don't miss. For rehabs and additions to existing structures, you also can get an abatement. It's due within the same calendar year as the permit was pulled. So if you got a building permit issued in 2024, it's due before the end of 2024, not 1 year, within the same calendar year. So it's due by the end of December, the 31st. Again, if you think 60 days, you'll never be late on something like this. Commercial properties, commercial fit outs, and commercial buildings, not commercial mixed use, but commercial, 60 days, same as new construction. Again, if you mess this up, let me know as soon as possible. We do all this work. We do the building permit. We have full-time expediting on staff because a lot of people mess expediting up. We do every license you can think of, every permit you can think of. We do all the variances. We implement everything start to finish. We handle this entire process. And for abatements, you get a copy of the building permit, file the abatement application. We have to email it to city. Do not physically drop it off there. Do not mail it. Please email it to the city so you have proof of it. And then we follow up 1,000 million times to make sure they got it, and we have proof that they got it. They then kick us over to the revenue department. We go through tax clearance. Sometimes there's filing issues. There's issues with an LLC, or accountant didn't do this or that. We help work through that. We make sure we get the approval documents. There is a document that you get from the city that says it was approved. There's no other thing you're getting. It's not like hidden somewhere. I have a lot of people say, oh, well, so-and-so said they had it. It's either a piece of paper, or it's not. And then once we get the CO, once the project's complete, we have to fill out what's called the certificate to commence, which we then basically say to the city, hey, the project's done, here's proof that it's done. And then they will actually implement the abatement. We then work through that and deal with revenue and OPA so that your taxes are correct and that it's reflected online correctly. It's all manual. It's not like Eclipse where there's this like internal sort of filing process. Everything is manual, and there's like a few people that you actually deal with that implement it. If you screw it up, if your client screws it up, if the developer they're purchasing it from or the person they're purchasing it from screws it up, please let us know. Weirdly enough, I have won almost every single nunc pro tunc that I've done. I think I've lost like maybe 2 or 3 of them in the past almost 10 years. I don't know why, besides I understand how they work and what they look for and what cases are good for a late filing or not. I always tell people too, with something like this, it's better to try it than not, because if you win, then we're in a better position than we're in. If we lose, we're in the same exact position, but at least we made an effort. There's no other way to get them approved late than go through what's called the nunc pro tunc process, which is what NPT stand for. Again, we do 15-minute free consults. I will take the time to sit with you, understand the facts, that give you the pricing, explain to you what I think is a good case or not. And again, like, we're not a consulting company that just says, hey, do this or that. We're a law firm, and I actually sit and implement and work through the entire process. So if I say we should do it, I also have to, with my team, do all the work. So, and again, I want us to be successful, make good use of the time and money. And again, I'm happy to always have the conversations. How to avoid it? Let us file your abatement applications for you. Again, we do them at a really insignificant flat fee. It's, again, just a service because we want to see people invest in the city. We want to make it easy, and we want to make sure it's done correctly. If you do screw it up, if somebody screwed it up, if it's pending, we've also come up with these escrow agreements so that you can move forward with closing. We'll hold escrow. We'll do the tax calculations for you that you can kind of negotiate to figure out what amount we should put in escrow in the meantime. And then we kind of draft all that and hold it, and also make sure we implement it and move forward as best as possible. This is a full list of our services. We do a lot of things. I think a lot of people don't know. I do a lot of zoning work, so a lot of people know that we do that, but we also do everything related to real estate, government, and business in Philadelphia and near Philadelphia. So if it's something that you don't know that we do, please reach out. If we don't do it, I'll be the first person to tell you we don't do it. I don't take every case. I have to want to work on it. Our team has to want to work on it. And there has to be like workability and chemistry between the team in general. We like to try to have it be somewhat of a nice experience for everybody. If we don't do it or we don't want to take it on, we will try to refer you to somebody who might want to take it on. We try not to leave people sort of high and dry, but again, we do spend a lot of time on these calls. They're 15-minute consults. Sometimes I go over if I really want to make sure that you know everything humanly possible. But again, I'd rather you reach out and ask us than not. That way we can make sure that we direct you if possible. The best way to contact us is not by texting my cell phone for any of you that have it. It is the best way to get a hold of me is contact@pritzkerlg.com. It's on the bottom right. If you do text me and it is urgent, I'll probably just ask you for your email, and then we'll set up a call. We do send a link. We try to automate a lot of stuff. We have to run conflict of interest. We have to make sure that we can represent you. We have to make sure that we haven't represented anybody adverse to what you're doing. And we also like to make sure we have all the contact information so that when we do get on a call, we can make sure that it's efficient and considerate of everybody's time and all the information that we need. Also, if you're not an email person, there's a phone number you can reach, and someone from our team will reach out and send you what you need or help you work through that. I know that was like a lot of information, but I just want to, make sure that I give you as much as I can on this. Again, I'm not going anywhere. I'm not retiring anytime soon, unfortunately. So if you need to set up a call, if you have any additional questions, please let me know. I'm going to kind of pause there and take questions. Again, if it's like for a very specific matter, I would just ask that we set up a call just so that everybody here doesn't have to listen to your personal matter or your client's personal matter.
Hey, Rachael, how are you today?
I'm good. How are you?
I'm okay. Thanks for coming to KW. We appreciate your input. I actually have 2 questions for you, but one of my questions is, So I have clients that will say they got hit the last time that the assessment came out and they just sucked it up and now they got hit again, big time. So if they go and they try and fight it, so is it just for this assessment or can they double back to when they got hit before or how does that work?
Yeah, it's a good question. You can't file an assessment for a prior year if you didn't file it on time. So it would just be going forward. They will though, and we do negotiate a lot of years going forward from that current year. So for 2023, we're getting them to agree to 23, 24, and 25. At a minimum, we try to get them agree to 2 years, but you can't go backwards. So I know there was a lot of people who may not have appealed, but we really can't do anything about prior years. But what I tell people a lot is it's better to appeal not every year if you can help it, which is why we try to negotiate at least 2 years, if not more than that. But people will say, well, it's not a big deal for this year. And if I pay you this amount and I'm only saving this amount, well, the reality of it is that we try to keep the basis low because over the time period of carrying a property, it doesn't really so much matter year over year. It matters within the lifetime of holding an asset. Our pricing is not crazy either. We do a flat fee, especially if you get an appraisal, but no, there's no way to accommodate for the year before. But on a going forward basis, we do try to negotiate at least 2 or 3 years with the city, and they've been amenable to that. Just because I don't think they want to negotiate it year over year, even though the city legally is allowed to reassess properties every year. I think there's a question in the chat that says, can they increase your assessment after appeal? Yeah, I mean, they technically can, which is why we don't go to a hearing most of the time. It's typically not after an appeal. It's typically they will either assess your property the next year, or if you, for example, the case that I mentioned earlier, the potential client, I was like, I would not want to take this case because you paid more for it than it's assessed at, and they could increase it if they wanted to, especially if we go to a hearing. They typically don't do that. Because number one, we don't really typically take cases where they should be doing that anyways. And two, we typically negotiate with them so we don't go to a hearing where they can increase it. But just because you go to a hearing and just because you file an appeal doesn't mean the city can't increase it. Again, we just try to mitigate that through our efforts. Another question, what was with the fee? It depends on the asset. It depends if it's a single family home. It depends if it's a multi-unit, and it depends how many units. If we have to pull rent rolls and do cap rates, and if you don't get an appraisal, it's a lot more expensive because then we have to do that work. But most people get an appraisal, and so we offer a flat fee also depending on the asset class. It just depends. Any other questions?
So I have another question.
Sure.
So this is an opinion question. People with abatements. So I work with investors and a lot of people who go down to the studs to rehab a property. But I find that oh, I'm sorry, a lot of investors don't go through the abatement process, and I just can't imagine what reason why they don't put in an application. Is there something that I don't understand? Why this seems very prevalent?
I think a few things. I think sometimes people build out properties without a permit. I've seen that a number of times.
No, I'm
Also,
talking about permitted people.
um, I think so. I'll just, I mean, and I don't know who you're talking about in particular, but I can give you kind
Hmm.
of over the last sort of 10 years what I've seen. Some people who file a building permit but don't file an abatement. One, sometimes they don't know that you can get a 10-year tax abatement for a rehab. People think it's only for new construction. I've heard that and seen that a lot over the last 10 years. So that's one reason. Also, some people think that their taxes are going to jump up astronomically if they file an abatement. They think that somehow the city is like hyper focused on their property. I'm not saying that doesn't ever happen, but the reality of it is that there are over 500,000 individual parcels of land in the city alone, and there are less than probably like 50 evaluators. So the odds of like people pinpointing your property so specifically that they're keeping up with the paperwork is a -%. It's just not possible, especially given the technology is not there for it. It's a very manual process. So I think that some people just do it because they think that their tax basis will be less, which maybe it will be, but long term, if you're spending, a lot of money on the abatement, the best way to kind of keep the liability down from a property tax perspective is to file the abatement, because the way that they do um, the calculations is they take the assessed value minus any taxable exemption like the homestead exemption or the tax abatement. They subtract that from the assessed value, and then what remains they times by the millage rate, which is 1.3998. So over the 10 years, it actually really saves you a significant amount of money. Even if you have an abatement on a property, we still do file tax appeals. There's instances where people will not people, the city will jack up the land value when you have an abatement because they're mitigating the taxable exemption, which is your abatement. They're trying to then raise the land value to kind of balance out not getting tax revenue for 10 years. We've successfully appealed a number of those just because there's been no reason that the land value has gone up so astronomically. This isn't like Dubai or like some place where values are like that crazy when you put bricks on it. We've also seen instances where they will increase the abated value and then randomly, like it'll be 300,000 of an abatement, then the next year it's like 340 and then it's 400. And typically, I think a lot of us are aware that like actually the bricks depreciate in value, the land is what goes up, not the other way. And what I've seen them do is they'll increase it, and then at year 11, they'll roll the tax abatement over the taxable exemption, which is the abatement, over to the taxable improvements. And then your value shoots up in year 11 to an amount that is insane for that project and for that property. And then we have to file an appeal in year 11. So that's some of like the reasoning, I think, and some of the things that we've seen them do, the city do to compensate for dealing with the abatement. That's not the proper way to go about it, obviously. And I always tell people I'd rather address it now than wait till year 11 when you get hit with a tax bill that you really can't stomach. On that like note, I will also say that if you guys are dealing with homeowners or if you have a personal home in the city of Philadelphia where you don't have the homestead exemption, and again, property.phila.gov, you either have it or you don't have it. There's no some other place it lives. If it has increased from I think 80,000 to 100,000, so they take the homestead exemption, they take that 100,000, they subtract it off the assessed value, and then you're taxed on the remainder. If it's your single family home, or even if you live in a multifamily building that you own, and you have you can have a homestead exemption as long as it's your primary residence. If you don't have an abatement, the homestead exemption is available to everyone. There's no like income qualifications. You don't have to apply for it every single year. And it will save a significant amount from a tax liability perspective. If you don't know how to do it, we can help you with it. It's really simple, but that's another way and another thing to look at as we're, talking about tax assessments and keeping property tax liability down.
Thank you.
Sure. Any other questions?
Yes, I have a question. This is Brandon with One T Mortgage. How are you?
I'm good. How are you?
Good, thank you. And thank you for your class as well.
Sure.
My question is for the appraisals. If someone bought a property this year, how old of an appraisal can they use for this process?
It's a great question. We need an appraisal that's dated the tax year we're appealing. So they would have to get it updated to reflect 2025. Sometimes the appraisers won't do that until January. That's okay. Like I mentioned, we don't submit the appraisal right away anyways. We wait until we start to negotiate with the city to share any documentation. But it does have to reflect the tax year in which we're appealing. So there's a lot of people who did refinancing or they just purchased a property. We ask them, instead of getting a whole new appraisal, just go to who you use and have them update it. And usually for a fee, they'll update it. Probably didn't change, or maybe it went down slightly or up slightly. But it has to be for the tax year in which we're appealing. So it would have to be dated January 1, 2025.
Understood. Thank you.
Sure. Anyone else? I'm going to put our email in the chat. As I mentioned, just reach out to us. If you have any specific questions, if you're not sure, it doesn't have to be tax assessment appeal related. It can be zoning related. It can be building permit related. It can be, I need help with a rental license. It can be, I want to convert this to an Airbnb. What do you think? A lot of cases, a lot of intakes I do, people just say, hey, I think I want to do multifamily. It's zone single family. What do you think? I'm happy to take those kind of calls and any kind of real estate related calls all day long. Most of my schedule is intake, 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 client issue, intake, intake, intake. So happy to answer any questions you have. No one's ever bothering me. I quit my job to build this company. I love it. I love helping everybody. And again, if we can't help you, we will, connect you. And also, if you need recommendations like architects, civil engineers, you're not sure what you need, city violations, a client has a concern. I will say though, if you are working with a client and it's their property and it's their issue, I do need something in writing from them saying that you can be on the call. I don't mind if realtors are on the call. I don't mind if other folks are on the call. We just do need, for confidentiality and privilege reasons, we do need the client, the person who actually has the issue, potential client, to approve that. Just because you waive confidentiality when someone else is on the call, unless that person is a lawyer. So just keep that in mind. So if we ask, it's not an offensive thing. It's just, we have ethic rules to follow. We make sure we do that. So, it says, will this recording be shared somewhere? I don't know, I guess. I'm not sure who's controlling that or not, but, Rodney, you have my cell phone, so you could just call me. If there's not any more questions, like I said, please reach out to us and, just let us know if we can be of help. And if there's anybody else that, may have missed this, that you think would benefit from this, feel free to share that information with them as well. And like I said, we're not going anywhere, so we're happy to answer questions as they come. And just as a reminder, the tax deadline for appeals is the first Monday in October. So we have a little bit of time, but just want to make sure that that's top of mind as well. And I hope everyone has a great Tuesday.